I want to thank all of you for being here today. Unfortunately, the truth is, as realists, the Supreme Court has fallen to the religious right. Since the 1980 presidential elections, I've been warning about how the Supreme Court could easily be provided with a first-time ever religious right-wing majority that would repeal the separation of church and state. If a religious right president had been able to fill strategic vacancies on the court, and if that same president had a Senate that would ratify those justices. Since the 1980 election cycles, we've had some cliffhanger near misses. Religious right-wing presidents have miscalculated how some of their nominees would have decided cases. President Reagan guessed wrong on Justice O'Connor, lucky for us, and largely on Justice Kennedy. The first President Bush, very lucky for us, guessed very wrong on Justice Souter. In the 90s, Bill Clinton put two church-state separation justices on the court. Respectively, in 2009 and 10, President Obama also put two church-state separation justices on the court. Now, in church-state separation, atheist, secular, humanist circles, it's become a joke that every presidential year, like some wind-up toy, I'm going to start running around warning about the consequences of the election to the Supreme Court. And I also call attention to the Senate races because it's the Senate that has the ability to accept or reject any federal judicial nominee. I've never in my life wished to be more wrong as much as I wish my ominous predictions about the court turned out to be false. However, given the numerical balance on the 9-member court, President Trump, by his Supreme Court nominees in 2017 and in October of last year, has succeeded in finally, for the first time ever, placing a 5-member religious right-wing majority on the United States Supreme Court. Now, what is the separation of church and state as we believe it to truly be? First articulated in 1947 by the Supreme Court, that no law respecting an establishment of religion, our cherished Establishment Clause. It means that all levels of government are prohibited from passing laws or undertaking actions that aid one religion, aid all religion, or prefer one religion over another. No branch of government can force or influence anyone to go to or remain away from any religious institution. No one can be forced to profess any belief or disbelief in any religion. And then in 1961, the court restated that same decree of what church-state separation means, and also declared that no branch of government may undertake any activity that assists all religions or any one religion as against non-believers. Another way was worded by Justice O'Connor in 1994, when she said separation of church and state means that no branch of government can treat people differently based on the God or gods they worship or don't worship. Justice Scalia represented a chilling minority view on the court that has unfortunately now become the majority position. In a chilling dissent from a Ten Commandments posting case in public schools in 2005, Scalia said it is demonstrably false to assert that the government can favor religion over irreligion. Well, if government can favor religion over irreligion, where does that end? He also wrote, it's entirely clear from our nation's historical practices that the Establishment Clause permits this disregard of polytheists, believers in unconcerned deities, just as it permits the disregard of devout atheists. This is frightening theocratic language. How can any government disregard those who adhere to different belief systems. We don't know how much overt discrimination against non-believers this new court majority, which is about to adopt Scalia's view, will permit. Where would it stop? Would the new court majority, reflecting the views of Justice Scalia, allow lending institutions to no longer make loans to people who won't affirm a belief in God? Could states now go back to the horrendous pre-revolutionary practice of barring people from testifying in court who won't affirm belief in a supreme being? When Chief Justice Robert, Associate Justice Alito, Thomas, and Trump appointees Gorsuch and Kavanaugh, for the first time now, we face a court that will talk about favoring religion over irreligion. But one member of these 5 new religious right majority justices is the most extreme. Clarence Thomas, appointed by the first President Bush in 1991, wrote that the Establishment Clause is the only part of the First Amendment that doesn't even apply to the states. His reasoning is very convoluted. He also said that the Establishment Clause was never meant to protect individual rights. And then, in what is really one of the most totalitarian pronouncements of all time from a United States Supreme Court justice, Thomas comes up with a distorted view that the Establishment Clause only exists to prevent the federal government from interfering if a state wants to have an official religion. So he believes that each state can actually even have an official religion if they want to. How did we get the 5th vote for the religious right? Justice Kennedy retired last summer, and the president replaced him with Brett Kavanaugh. Though we would lose Kennedy's vote in a number of church-state separation cases, he was with us on the core issue of equality before the law for believers and non-believers. He was happy to see his former law clerk succeed him. But there is a vast difference on our issues between moderate Anthony Kennedy and religious right-wing extreme Brett Kavanaugh. In a 2017 speech, Kavanaugh praised the efforts of former Chief Justice William Rehnquist to undo a strict wall of separation between church and state. Kavanaugh approved of the way Rehnquist characterized the wall of separation as based on bad history. Kavanaugh praised a dissent in 1985, a year before Reagan made Associate Justice Rehnquist Chief Justice. In this case, a majority of the court struck down an Alabama statute that required a moment of silence in public schools because a legislative history demonstrated that the Alabama legislature really wanted to sneak prayer back in. Now, it's frightening that Kavanaugh endorses a dissent that approves of the contention by an early 19th century Supreme Court Justice Joseph Story that Christianity ought to receive encouragement from the state. In this same speech, Kavanaugh praised Rehnquist's legacy for leading to the decision in Town of Greece versus Galloway, which upheld the practice of formal sectarian prayers at local government meetings. Kavanaugh is on record as opposing the government neutrality in matters of religion, that benevolent neutrality in which we are all to be equal before the law, regardless of our metaphysical views. And he wrote, when he was a judge on the D.C. Court of Appeals, stripping government ceremonies of any reference to God or religious expression would reflect unwarranted hostility to religion and would in effect establish atheism. Well, this is a horrendously prejudicial view for a now Supreme Court justice to have of atheism. By Kavanaugh's very reasoning, we could also assert that by stripping government ceremonies of any reference to a godless, naturalistic universe, we would be reflecting unwarranted hostility toward atheism and be, in effect, establishing religion. It would go both ways. To also show you a major difference between Kennedy and his successor, Kavanaugh. In 2000, the Supreme Court ruled by a 6-3 majority that a policy whereby a school district allowed student-initiated and student-led prayer as a formal ceremony before the start of high school games was unconstitutional. It was just a ruse calling it student-led so that they could sneak those official prayers in as part of a formal function of a public school. Kennedy voted to strike down such prayers. Kavanaugh filed an amicus brief urging the court to uphold them. There are ominous signs the court is on the verge of overturning our 72 years of precedent on church-state separation. 9 days ago, on February 7th, in Dunn versus Ray, the court denied a request of a Muslim death row inmate to have an imam present at his execution in Alabama. The state denied the request, and the 11th Federal Circuit Court of Appeals issued an order requiring the prisoner to be able to have an imam attend him the last moments of his life. In a 5-4 decision, the court reversed the 11th Circuit, and the execution was carried out the same day without an imam being present for the condemned prisoner. In dissent, Justice Elena Kagan pointed out that Alabama always allows Christian prisoners to have clergy present at their executions. She rightfully pointed out that the majority was wrong in deciding that the prisoner waited too long to assert his claim because he only waited 5 days until after Alabama denied his request to have an imam. Now, this case, just 9 days old, serves to highlight the true meaning of separation of church and state as we believe it to be. If properly applied, it means no branch of government can favor individuals or groups of believers over non-believers, and no branch of government can favor one religion over any other religion, and no branch of government can favor religion collectively against non-belief. The majority decision in this case, denying a Muslim prisoner the right to have an imam present at his execution, was a gross church-state separation First Amendment violation because it allowed the state to favor only Christian condemned prisoners. The way this should work is that if an atheist wants a secular humanist counselor, if a Christian wants a minister, a Catholic wants a priest, Protestant minister, Muslim an imam, a Buddhist priest, you have to treat them all equally. See, sometimes people on the right, the religious right, claim that we church-state separationists, particularly those of us who are known atheists like me, are trying to get special rights. That's absolutely wrong. We just don't want to suffer fewer rights than anyone else. Everybody is to be equal before the law, irrespective of their view on how the universe is put together. That is the objective. Now, in the Louisiana abortion case, again on February 7th, in June Medical Services versus Gee, Chief Justice Roberts joined pro-church state separation justices Breyer, Ginsburg, Kagan, and Sotomayor in staying the implementation of a restrictive law passed in Louisiana that would have required doctors performing abortions to have admitting privileges in a licensed hospital not more than 30 miles away, and the abortion clinics would also have to have hospital-like capabilities. We should take no comfort in the fact that the Chief Justice voted to stay this law until the court has a full hearing. Because in the 2016 case of Whole Women's Health versus Hellerstad, where the court voted 5-3 to strike down a virtually identical Texas anti-abortion law, Chief Justice Roberts dissented and would have upheld the law. We know Kavanaugh will vote to uphold the Louisiana restrictions and reverse the Texas decision. The Texas decision striking down the Texas abortion restrictive laws had 5 votes in favor of declaring those abortion restrictions unconstitutional. Anthony Kennedy was among the 5 justices. So once again, we see the tragic consequences of Trump's replacement of Kennedy with Kavanaugh. Now, on January 22nd last month, in Trump versus Jane Doe II, the court reinstated the president's ban on transgender people serving in the military. The ban will remain in effect until the court fully considers the case. It was another 5-4 decision. But in upholding the ban on transgender people serving in the United States military, the court vacated numerous lower court injunctions that blocked the law's implementation. So this is, again, a very ominous sign. Now we come to the case that might immediately nullify church-state separation, either partially or completely. On February 27th, this month, the court will hear oral argument in the combined cases of Maryland National Capital Park Association versus American Humanist Association and American Legion versus American Human Association. This is the case in which the presence of a very large Latin cross on public property as a war memorial in Bladensburg, Maryland, was rightfully declared unconstitutional by the Fourth Federal Circuit Court of Appeals. When a party prevails in the lower courts like we did, it's a very, very bad sign when the Supreme Court takes the case. If the Supreme Court agrees with the lower court ruling, they will not take the case. This is a very bad sign. Unfortunately, all the legal scholars involved in this on our side anticipate we will lose this case. The question is, how badly will we lose it? The court could uphold the presence of the cross as part of a long-standing memorial, which would be bad enough. It could do so without any further sweeping pronouncements, or it could uphold the presence of the cross by striking down all the prior precedents disallowing religious displays on public property. The court could also allow the cross to remain where it is by a wholesale reversal of church-state separation and state overtly in a 5-4 decision that government now, for the first time ever, can favor belief over non-belief. We will know the result either in June or sometimes before, but this is a very, very frightening turn of events. The special privileging of religion is incompatible with church-state separation and with the equality of believers and non-believers. If only those with religious objections can avoid with complying with otherwise universally applicable laws, then our legal system is providing a special privilege to only the religious, which special privilege is unavailable to anyone else. This is not consistent with the benevolent government neutrality that we're desperately trying to preserve. In 2014, we lost the case of Hobby Lobby versus Burwell in a 5-4 decision. The court ruled that individually religious employers who have a secular business doing business with the general public are still entitled to a religious-only special exemption from the otherwise universal mandate of the Affordable Care Act that employers provide their employees with insurance coverage for contraception. Last year, we also lost the case of Masterpiece Cake Shop versus Colorado Civil Rights Commission. Here, the Civil Rights Commission of Colorado ruled that Colorado's civil rights law prohibiting discrimination against members of the LGBTQ community prohibited a Christian cake baker doing business with the general public from refusing to bake a cake for a same-sex wedding. But the Supreme Court said the commission was wrong, but it was a narrow decision because it said that commission members expressed hostility toward the religious beliefs of the baker. Now, whether or not that is true, we do know that Brett Kavanaugh would provide the fifth vote to outright give a religious baker special rights to avoid complying with the state's civil rights laws. If only the religious, upon a mere assertion of religious-based objections, can avoid complying with laws that otherwise bind the rest of us, the extent to which such religious claimants could discriminate against certain members of the public is by very definition open-ended. Where would the court say, oh, but this you can't do? You can do this based on your religion. You can stop doing business with these people, but you can't stop doing business with those people. Under the Affordable Care Act, regulations were issued so that some employers with religious objections could opt out of the otherwise universally applicable mandate that employers provide insurance coverage for contraception. Such religious employers are required to file a form alerting either the government or the insurer that they will not provide coverage for contraception. Once in receipt of such notification, the insurance company then has to provide this coverage directly to employees under a separate plan. So there is a way out for these religious employers if they're institutional religions. Kavanaugh's record on this was atrocious when he was on the D.C. Court of Appeal. In 2015, he participated in an en banc, which means the entire court, deciding a case. This happened in the case of Priests for Life versus United States Health and Human Services Department, an organization of Catholic priests who oppose abortion and contraception wanted to opt out of even this minimal notification provision. Can you believe this? They claimed that to file a form with the federal government or the insurance company saying that they won't provide contraception means that by so notifying the government or the insurance carrier, they are enabling the government or the insurance carrier to help the employee get coverage for contraception anyway, and that even this violates their religious beliefs. The court ruled 9-3 against these priests. Kavanaugh was one of the three dissenters. He wrote that as long as employers sincerely believe that a course of conduct violates their religious beliefs, the government cannot inquire any further and must not force compliance even with something as minimal as filling out the two forms. Kavanaugh maintains that once the priests merely state that their religious convictions are violated by participating in the notice requirement, that they should be exempt from even that. Now, such religious claimants, quite frankly, behave like spoiled brats throwing a tantrum in the sandbox. They're not even satisfied with being able to opt out of providing direct coverage for contraception for their employees, which is already an enormous concession that they've been given. They don't even want to have to notify anyone of their decision so that the lack of notification can further hamper the effort by these employees to obtain contraception coverage on their own. With enablers like Kavanaugh, our legal system is in danger of allowing only the religious to have special rights to disobey laws that are binding on everyone else. Let's look at these implications. What if the owners of a restaurant that does business with the general public claim that they have a sincere religious belief against doing business with atheists? They even have their minister verify that this is a tenet of their particular sect. Would Kavanaugh allow the restaurant owners, in the middle of a busy day serving the general public, to refuse to seat an atheist at the lunch counter? What kind of bigotry does that conjure up? What would be the limit of the type of discrimination against third parties that would be allowed to such religious claimants? Now, when the president nominated arch-conservative religious right-wing Brett Kavanaugh to the Supreme Court, he was supported strongly by evangelical Protestants, though he is a very devout Catholic. However, people seem to forget that just a few years ago, when he was a judge on the D.C. Circuit Court of Appeal, he voted to allow the Navy to continue to give better retirement benefits to Catholic clergy than to Protestant clergy. Now, what would the majority of evangelical religious right-wingers say to that? So here's a double violation. Not only does Kavanaugh favor the unconstitutional permission of favoring belief over non-belief, he would allow branches of government to favor one religion over others, particularly if it's his religion. Must be some very strong beer. Now that the religious right knows they finally achieved the Supreme Court majority, we can expect an avalanche of religion-promoting legislation and activity at all branches of government. A menacing theocracy is looming on the horizon in the form of Project Blitz. It's an effort to overwhelm secular government with a torrent of religion-promoting legislation in the state legislatures, from mandating the posting of "In God We Trust" signs to allowing adoption agencies to refuse to allow LGBTQ persons to adopt children. The Project Blitz proponents start with symbolic gestures, like posting "In God We Trust" signs in public schools and as bumper stickers on police cars. But then there is an effort to actually promote Christianity in the public schools. A recent aspect of this was Trump's tweet fully supporting going back to teaching the Bible in the nation's public schools. Then, like Mississippi's 2016 law, there are efforts to allow businesses that deal with the general public to openly refuse to serve LGBTQ customers if the refusal is based on sincerely held religious beliefs. Project Blitz has already organized more than 750 state legislators through state legislative prayer caucuses. Last year, they got 76 bills introduced in 26 state legislatures. This week, Americans United filed suit in federal court in South Carolina because a ministry receiving taxpayer support refused to allow a Catholic family to be involved in a foster care program for children. The organization will only allow evangelical Protestants to do so. The major points that Americans United will be making in this lawsuit are: it's unconstitutional for government-funded agencies to discriminate against prospective foster parents and volunteers based on their religion. South Carolina and the Department of Health and Human Services may not spend or provide tax dollars to faith-based foster care agencies that use discriminatory religious criteria. The Department of Health and Human Services did not follow proper procedure when it excused South Carolina and its foster care agencies from following federal anti-discrimination law. We must please understand this. President Trump's Department of Health and Human Services allowed these foster care agencies to be exempt from federal anti-discrimination laws based on religious discrimination, even though they were receiving public money. Now, what is it that we can do that now that we are facing a first time ever religious right-wing majority on the courts and on the Supreme Court? Well, first of all, next year is a presidential election year. And so it's kind of self-evident what's entailed with that. But also it is a Senate election year. And it's also self-evident what's entailed with that. But with a shift on the federal courts and with the hostility in state legislatures and the way we will now expect the Supreme Court to uphold religion-promoting legislation from the state legislatures, what we have to do is we have to start electing church-state separationists, regardless of their personal religious views or belief or non-belief. We need to start electing people who would uphold the separation of church and state to the 50 state legislatures. It's a very difficult task, but it is overdue. We also have to learn from how the religious right took power in the early 80s. They began electing people to local school boards, to city and town councils. The school boards were very important for them to push their creationist agenda. We need to learn this, and we need to strategically start electing our own. And by our own, in this context, I'm not referring to people that share the same view on how the universe is put together, but people who, regardless of their religious convictions or lack thereof, share the same view that government must treat everybody equally, regardless of viewpoint on matters of religion. There's a realistic possibility that when the new Supreme Court, and we must understand that if for any reason Justice Ginsburg, anytime this year, is unable to continue on the court, President Trump will put the 6th religious right-wing justice on the court. Also, we are a nonprofit 501c3. We can't endorse or oppose candidates, but we can talk about substantive issues and predictions. The outcome of next year's presidential election is by no means cast in concrete one way or another. So we must bear in mind the implications for more sweeping religious right-wing justices to populate the court. Realistically, there are many, maybe most of us in this room right now, who, if we lose church-state separation, will not live to see its return. But that can't stop us from working toward getting it back if we lose it. It could take multiple generations to get back government neutrality in matters of religion, given the prospect of young religious right-wing Supreme Court justices who could be there for at least 35 years. But the struggle is so important that it's a battle we have to wage, regardless of whether or not we live to see the outcome, and it's a battle we have to wage whether we ultimately win or lose. And I also, as a member, along with Steph, of the Board of Trustees of Americans United, want to thank you for your support for the organization, want to ask you to please continue to support the organization, and want to particularly congratulate Steph on the marvelous work she is doing in a county that still could be a little bit sketchy in terms of separation of church and state and individual liberty of conscience for everyone. But regardless of the outcome, regardless of how bleak it is, we cannot concede the United States of America to the religious right for them to turn it into a theocracy. So whatever it costs, whatever it takes, let's devote ourselves as best we can to ultimately preserving for all time the separation of church and state. Thank you very much. Sure. Yeah, please, yes.
Yes, thank you for your talk. I acknowledge the importance of the down ballot, but I also have to admit that I myself have been guilty of ignoring the down ballot, election candidates for judges, for schools, and so on and so forth. One thing that I would like to know is, what are good reasons, and maybe other people have ideas, what are good resources for finding out where these down ballot candidates...
Very good question. For those who didn't hear it, an excellent question on how to find out the relevance and position of down ballot candidates on these issues. Well, it depends on the office they're seeking. With judges, judges aren't supposed to articulate a position on any issue, so that they're automatically excluded. Particularly when it comes to the state legislature or school boards, you can ask the respective candidates who appear on your ballot running against each other where they stand on these issues. And then you can make your decision. But the way to find out is to call their campaigns and ask. Now, here's something very important. If candidates tell you that they haven't thought about these issues, then you need to choose the one candidate that you think might still be the best. But if any candidate obviously says they're with us on a number of these issues, that's something that you should know. But you're right, we ignore these. Yes, please.
I was just going to say that I usually put out a recommendation on judges, and one way that I check, I go to the right-wing websites because they do all the research, and you see who they're recommending for judges, for school board, and then you vote the opposite way. And just so people know, our
yes.
current Department of Education has a majority of religious right people on it, two of whom are
I just before I have to say again, the comment she just made, very important about a majority of religious right-wingers still dealing with boards of education in this county. It is through boards of education that the religious right began to consolidate political power. Yes, I'll go, yes.
I wanted to know what your thoughts are on the whole congressional process with Kavanaugh and what happened and how he was coached and how he got on.
Can we go back to the previous topic for just a moment, though?
Go ahead.
I'm sorry. But I just wanted to ask.
Well, let me just address that, and that is that we can dispose of that right away, which is the only answer, and it will not serve us to go into the specifics of the Kavanaugh hearings. The only lesson to be taken away from the Kavanaugh confirmation process is that in terms of the Supreme Court, Senate elections are as important as presidential elections. Yes, ma'am.
I'm sorry, I didn't mean to interfere with your question at all. I just wanted to add to what Felicity was saying, and to your question. And please don't feel embarrassed or ashamed. Most of us have not taken enough interest in the down ballot. We're a different population now, or many of us are. So one of the things you can do, which is very simple, is when the ballots come out, or even before, when you know who the candidates are, for school board, water board, even city councils, is just go on and Google the names. Because people who are running for office have often made statements or been quoted in the newspaper, etc. And you can begin already to feel, and then go on their website and look to see what positions they have taken. And the case in point that Felicity just mentioned, the president of the board of the Orange County Board of Education has on his website and on the district's website, in his bio, that he favors marriage between a man and a woman only, and he is pro-family and pro-life. And that tells you everything you need to know. And he behaves like that. He enforces it over and over again. So you don't need to go too deep in the weeds. You can just Google, and you will get some information. And Felicity's right.
And if you don't find anything on Google, it's good to call the candidates. Yes, you had your hand up first.
The example you talked about a restaurant owner being able to discriminate against atheists, how would he figure out who's an atheist and who's not? Would he then
Let's say that he's able,
would he be able to, when you walk in his stores, that you have to take a religious oath or something?
maybe not, but if an atheist is known. So for instance, let's say Richard Dawkins is visiting the United States and his sponsors bring him to that restaurant. He could say, well, I won't serve you.
I just see how stupid that is. He could then discriminate against anybody. Just
Okay, exactly. See, that's the point I'm making. The trouble, the reason why we are in such fear of this is when people like Kavanaugh and before him Scalia and Alito particularly, when they say all you have to do is express a sincerely held religious belief and you can dodge compliance with an otherwise universally binding law, they don't put any limit on it. So we are all just speculating as where would they say, okay, but you can't do that. If you and then yeah, please. Yeah.
Is it possible there might be some way within the organization or our like organizations to create some sort of research arm so that we would be able to post information about how these local candidates function?
It's a good idea, but in a way it is problematic. It takes a lot of resources, and also we can't, like the religious, get away with. We don't want to come close to like voter guides endorsing or opposing candidates. Well, Americans United has stopped churches from doing this. So it would have to be done with just an objective listing of the truthful positions of the candidates with no editorial commentary. It's a very, very good point you're raising. It's a question of resources. And it's a question of resources because there's, I mean, in all the countless cities and towns and counties in the country, it's actually something local groups might want to undertake in their own region. A nationwide organization just doesn't have the resources to do this. But it's a good idea. I think maybe what will come out of this meeting as an actual action step will be that a number of you will be able to do this research and then inform the rest of the members of the Orange County chapter of a candidate's position on relevant issues. I think something is percolating up here that could be promising. Yes, ma'am, you have a question.
I know this is an absolutely absurd question, but why would it be impossible for a class action suit by the American people against some of these Supreme Court justices based on the fact that they're not adhering to the principles of the Constitution, but to their own religious or political beliefs?
The reason why that wouldn't happen is because the very nature of law is open to interpretation. And so you would have to argue that there was a violation of law in a decision that was extreme, and then that wouldn't open the door to a class action lawsuit, that would open the door to impeachment. But we also, taking the panoramic, mature view, as tempting as it is, we don't want to set a precedent where any interest group on any side of an issue can start the impeachment process against a justice. Because first of all, we need an independent judiciary. Secondly, realistically, it'll be used against ours as frequently as against theirs. And we can't risk that. Actually, the sobering truth is, as I've been saying since the 1980 elections, the sobering truth is, if you care about the Supreme Court, make that the or one of the primary issues you look at in choosing a presidential candidate to vote for. And the same with the Senate. Elections really matter. Had the 2016 presidential election turned out differently, we would now have 6 church-state separation justices on the Supreme Court. So elections do matter.
But census matters too.
Excuse me?
Census matters also, because if they make the district lines in a certain way, they can pack their local legislative, and they gerrymander it so that our people don't get in, no matter how hard they try.
See, now that's a very excellent point, that the determination of the census and the drawing of congressional and other lines, what has to happen there is voting rights individuals need to file those lawsuits as they do. This is not something that we as an organization can do. We have our hands full with the specific issue, but you're right. You're right. It's the drawing of lines in Texas and other states that results in religious right-wing victories. So the problem, though, is why this would be far afield for Americans United is you cannot bring such legal action based upon the issues that will be short-shrifted by the gerrymandering. It must be based on the category of people who will be disenfranchised. And that's outside of our purview, but it's a good point. Yes. Yes, please.
Have there been surveys done or polls done? Is public opinion moving in the religious right direction or in our direction, or are people even aware of this issue?
Your latter point is the most telling. Many people aren't even aware. Now, here is the polling, as you rightfully suggest, is not very well done. A majority of Americans still believe that there has to be a belief in God for someone to be morally trustworthy. Now, that can percolate down to all sorts of other things. It might be the bland, some of us will remember, it wasn't religious right, but it was an annoying belief. President Eisenhower's, I don't care what God you believe in as long as it's a something. Well, a lot of Americans still do not consider you a trustworthy co-American unless you believe in a something, even if they can't define it itself. So it's a cultural problem. The cultural problem in this case is not religion. The cultural problem is the belief that those without religion can't be equally moral or trustworthy. And a refusal to look at the enormous intellectual firepower that also exists among a number of non-believers and the kind of philosophical arguments. So what I would say to people is I say to religious voters, you don't have to be an atheist or support atheism in your voting, but when you see the intelligence with which atheists approach these philosophical discussions, you don't have to worry about intellectual integrity or moral upstanding qualities. See, again, until the American people see everyone as equal regardless of their metaphysical views, we're going to have this problem. With respect to abortion, the polls show most people are pro-choice, but once you get into specifics, it starts to dwindle. Most people are pro-choice only for the first trimester. Then we lose the majority. Most people are pro-LGBTQ rights and pro-same-sex marriage, but it's soft. Most Americans still would like to see some kind of prayer offered in school because they believe that teaching kids about a divine overseer might be necessary for the kids to behave. I mean, that's still, you see, once again, the bare majority of adult American voters are afraid of people who don't believe in divine accountability. So you see, you raise an excellent point. The answer to your question would be more precise wording. But it's a very profound question because it goes to kind of the vague notion that most Americans still have, that it's still better to fear a supernatural being than not fear one.
It also requires a degree of critical thinking in order to understand the philosophical basis for atheism, and I'm not sure that most people have
But you
that.
see, my point is, for purposes of Americans United, our objective is an America where believers and non-believers are equal. So when I ask believers who are prejudiced against atheists to look at how we approach intellectual issues, in that instance, other than when I'm debating for atheism, it's not for them to become atheists, it's for them to agree to atheist equality. And in fact, I'm very, very involved in the effort to have equal rights for everyone. The problem is as you see with people like Vice President Pence, they believe that unless the religious get special privilege, they're being discriminated against. I was horrified 20 years ago when the super powerful TV arch religious fundamentalist preacher Pat Robertson, at the height of his power, said that Christians are as persecuted in America today as Jews were by Nazi Germany. And it was particularly hard for me to swallow because my mother was an Auschwitz survivor. So I wrote to Brother Pat and explained that there's some differences. But it's this kind of thing we need to avoid. Yes, please.
Yeah, a quick question back to your restaurant model. If I had a restaurant that had 80 sex offenders working in it and doing their thing, I have a feeling that the government would somehow figure out a way to shut them down. And so I'm using the model in San Bernardino where they have 80 priests that are being indicted or acknowledged sex offenders. And I'm saying, shouldn't the Catholic Church be shut down? And shouldn't their tax benefits be eliminated? Are we doing anything?
Well, it's a very, very important question. The only way to get at that is that when there's a specific church-state violation. Now, what I've been involved in, unsuccessfully, is to make sure, at least in my home of LA County, that prosecutorial agencies don't give special leniency to Catholic clergy. The worst example of this is that a succession of LA County district attorneys have refused to prosecute former Cardinal Roger Mahony, even though he admitted that he protected child abusing priests in the 1980s because, get this one, talk about religious privileging, all the information wasn't yet in about how bad child abuse is.
Really?
This is Cardinal Roger Mahony. So what needs to happen is that branches of government must not treat clergy child abusers or institutions that protect clergy child abusers differently than they treat other child abusers or non-religious institutions that protect child abusers. But shutting down an entire church or lifting the tax exemption, that would have to be a church-state violation like endorsing candidates. You see, the thing is, what 501c3s can't do is endorse candidates, but it can take positions on issues. So, for instance, a Catholic priest can stand up in church and say, we must ban abortion. If the priest says, vote only for anti-choice candidates, that's getting a little bit murkier. If the priest says, right now, where this church is located, there's a contest for the state assembly, candidate A is pro-choice, candidate B is anti-choice, decide for yourself. That could also be murky because that has a very strong implied endorsement. But the core of the value of your question is the shamefulness worldwide of governments everywhere allowing Catholic clergy special leniency. In 2000, 5 years before becoming Pope, Cardinal Joseph Ratzinger wrote a letter to Catholic dioceses all over the world telling them not to turn their priests in, but to handle it internally. Yes, yes, please.
The other thing that keeps me up at night, besides the Supreme Court and the threats on the Johnson Amendment, are the call for a constitutional convention of the states. Can you speak to that at all?
Okay. You're raising an important question that we usually forget to talk about because it is a torpedo flying deep underwater. But some legal scholars say it's still coming at us. You would need a very large number of states, I think 3/4 of the states and 2/3 of Congress, to call for a new constitutional convention. And if that occurs, it means the entire United States Constitution and Bill of Rights will be up for grabs, and it can be entirely rewritten. We don't want, and I just have to say this is not any kind of elitism. This is not any kind of condemnation of the so-called average American. It's just a statement of where we are today. We do not want to entirely throw out the wisdom of our 18th century framers, flawed though they were, and let today's popular majorities redo the entire Constitution. We can't risk that. And thank you for bringing that up.
And there are several movements, I understand, and one has only 6 states left to go before it's ratified.
That I need to check into. Okay, that I'm not sure of. If that's true, you've given me the most important piece of information that I've heard since the beginning of the year.
I'll email you.
Please do. Okay, I'm going to ask you, I'll give you my email. I need to see this because we can't afford this. Because
Common Cause has a lot of stuff on its website
Who?
about the organization Common Cause.
Okay,
It
all
has
right.
a lot of information on its
Okay.
website about that.
you see, one thing we do know, a majority of Americans do not believe that free speech should be as unlimited as it is. Most Americans do not agree that comments and writings and movies and books and films that are deeply offensive should be protected. But if you do that, you reduce the First Amendment to nothing more than an umbrella that's taken away as soon as it begins to rain. If we lose free speech, then we'll have blasphemy laws, and it would be nightmarish. So if in fact this is happening, we're going to have to start an outcry. I'm not exactly sure where we are, but I will look into it, and thank you for raising it. I hope it's not that close, because so far today, I've come here saying the water level is already here. If the Constitutional Convention is there, particularly for a little guy like me, it's way up there. Thank you, though. Yes.
I have a question for you.
Yeah, please.
I'd like to go back to the South Carolina case that we just,
The what?
the case in South Carolina.
Yes, yeah.
We just started.
Yeah.
Because it's a Catholic, if that goes to the Supreme Court, how do you expect that the devout Catholics on the court will handle that?
It's interesting. How would the Catholics on the court handle it? Well, first of all, I would say that I could see on this one a clear majority, even with the pro-church state separation justices saying you can't do that. However, to the extent that you have a number of the Catholic justices committed to allowing religious preferentialism, we don't know. It's an excellent question, so we have no idea what they would do with this. I do know that Scalia would probably strike it down, because Scalia was very concerned that government not favor one branch of Christianity over others, but privilege Christianity as a whole, even though he was a Catholic. And in fact, when Scalia dissented in the same-sex marriage case, he said that one of the problems is that there were no Protestants on the Supreme Court, and that they are insulting many evangelical Protestants by allowing same-sex marriage. So Scalia wanted to protect the entire sphere of religious Christianity. But that's an excellent question. We don't know how that's going to turn out, but we might find out if the court takes it. Yes, please.
I used to quip to people a long time ago about the religious right, trying to get these laws in to favor them. But wouldn't that backfire on them and be equally used by Muslims and others? And I think they're kind of telling me that I think they're going to carve it up so it's only a certain religion and not be able to be utilized by any religion.
Well, but you see, you raise an important point, because even Scalia, trying to exclude Buddhists and pantheists and deists, did embrace equal protection for all monotheistic religions. That would include Islam. So we don't know how that would play out. I hope we're not at the point, I don't see it yet, I hope we're not at the point where we're going back to the early days of the Supreme Court. We had extremists like Joseph Story who believed in Christian preferentialism. I hope we're not there yet, that we're not getting back to that. Kavanaugh's decision with the Navy and the Catholic versus Protestant retirement benefits for chaplains was a bit startling in that regard. Yes, Jane.
Going back to local candidates, has anybody here done the research on the supervisorial election, what's going on now with Florida Sanchez and Murphy? Anybody have ideas which one we could?
I didn't catch that.
Supervisorial, the local county supervisor. There's another election I know with one of the districts. Florida Sanchez is one, and Mayor Murphy from Wagner, pardon me. Has anybody done any research on that?
Wagner's a religious right.
I think Ron Wagner's one.
Okay, well, you see, again, for our purposes, what you do, call each campaign with questions on these issues and see what they say if they'll address it, and also Google them, as was pointed out. I mean,
We'll talk to you after.
yeah. I mean, this is.
He's gonna get an earful.
Yeah. I mean, this is, but you see, it because we are about to be devastated at the national level. The harshest reality we have to face, all of our lives, when it came to personal freedoms and the rights of conscience of everyone, regardless of what legislatures did, we go to the Supreme Court, and they would provide the remedy. Now the court will be on the side of the religious oppressors. This is the first time since any of us have been alive that the net has been removed from under the tightrope. So the strategy has to turn local. So if all of you among yourselves can discuss this and sort of get into a kind of process whereby people can be notified, it's very important, particularly races here in the OC. Any other? Yes, please.
Would you care to comment on the fact that Trump's emergency declaration may end up in the Supreme Court?
This is not within the context of Americans United issues, so it's not a, no, it's, I'll decline to comment on that, if that's okay.
Thank you, Eddie.
Thank you.
You gonna hang around?
I'm hanging.